minute, sir. Okay, sir. Yeah.
Sorry, people are waiting. I guess I'm very sorry actually.
So I'll make an introduction. So 1 minute, sir. 1 minute, sir. Yeah. Welcome you all to the session 2. I want to start this session with the inspirational quote: "Opportunities don't happen, you create them." Mr. Srinivas, founder and managing director, completed his BE Mechanical from Madras University, Masters in Mechatronics from University of Siegen, German. He has an ability to evaluate and respond to customer needs. He has also been the lead consultant to the engineering and manufacturing sectors in and around Hyderabad with ISO consultation and enabling them getting registrations. He also provided services to many other markets with registration and certification to programs such as Information Security Standard, ISO 27001 and ISO 13485 for medical devices, as many more. His technical expertise comprises automation and industrial communication, advanced control, electrical machines and power electronics, machine dynamics, and system dynamics. He has been in many positions as lead consultants for patent, trademarks, and copyrights in EY, IP, and IT Services Private Limited, Hyderabad. And he was also the lead auditor of consultant for implementing ISO standards for EY quality certification services. Hyderabad's clients in Telangana, Andhra Pradesh, and Karnataka. Thank you, sir. The session is yours. You can go on with the sessions.
Very good morning, and thanks for giving me this opportunity to Pratisha College of Engineering under Atal ADC. Thanks for joining today, this afternoon. Sorry for making you people wait for at least 15 minutes. So today's session, I hope other speakers, Swapnil clarified most part of types of IP and the patent filing also. I hope, yes. What did he cover actually?
The patent filing. Yeah, someone.
Yes. Yes, ma'am.
Yes, the patent drafting, filing, everything is finished out, sir.
Okay, so we are dealing with what is the publication examination and what would be the objections in the stage of examination, right?
Yes, sir. Yes, sir.
Yes, ma'am.
Yes, sir.
Yeah.
Yes, sir.
So, brief overview how a patent can be filed and what is the its life cycle actually. So filing of application can be done provisional application can be filed or a complete application can be filed. And what is the difference between a provisional and complete? If you ask me, like a provisional specification at the stage of idea, or still you have to build the product for prototyping, testing, or you cannot visualize, or you want to further work with other inventors, or maybe you need some more time to file complete specification. In either of the cases, like you can file it as a provisional application so that the application will be filed. That means like you will get a patent application number. So it is no different when compared with the complete or the other forms. So the initial application could be a provisional application and you'll get a patent application number and you can start using it as patent pending and you can display that number. But this provisional application will not be published. It's all secret between you and the patent office. So even you search in the online medium in the status page of India Patent Office, so you won't see anything. Anything means like it shows like application not yet filed or not yet published. So that's the message that you will get with a provisional application. So a complete specification need to be filed. If it is a provisional application, a complete specification need to be filed within 12 months from the date of provisional application. Or you can actually post-date that provisional date up to 6 months. I hope like the voice is clear, right? I just want to check. Ma'am, the voice is audible, the screen is visible,
yes.
Right?
Yes, sir, it's clear and visible, sir.
Yeah, sorry. So after a provisional application, a complete specification need to be filed within 12 months. Or if you are not ready yet, you can file for post dating of the provisional date. So post dating means like you are leaving or you are losing your priority date. That means like you can lose by days or by months, but up to 6 months. You can file n number of times. That means like, for example, we filed a provisional application today or last year the same day, and the complete specification is due today, for example, and we want more time. For example, we need 10 days. We can file a post dating request for 10 days. That means like 28th July 2020 is moved to 8th August 2020. That means like you are losing your priority date by 10 days. So that can be done up to 180 days, n number of times, but not beyond 180 days. So this is what the provisional specification and difference between like the post dating aspect of it. And complete specification, yes, 12 months is the due date, and after complete specification only the application moves to publication. And that too, if we ask for early publication or mandatorily after completing the 18 months time period from the date of filing. So for publication, it should be 18 months old. If we don't ask for early publication, so the application will be published. Publication means it's not similar to paper publication. As you all the participants today, you all know the paper publication, how it is and what it needs, but it's not similar. So patent publication is nothing but putting it to public. It's not like they won't review, they won't examine, they won't search. They first put it to the public. That means like they make it available on the IP India Patent Office portal, and then they'll take it for examination. What is the need? Why it is so? Why it is not reviewed, or why it is not examined, and why it is published without examination? The Patent Act says like if there is a third party, for example, if someone wants to file a pre-grant opposition, he should know what the application contains. So for reason this publication is made. So before examination, the application will be made public, and then it is taken for examination. And meanwhile, before examination report, or even after examination report, before grant of a patent application, a third party who is not, he is the aggrieved party, but any third party can file a pre-grant opposition. So for that reason, to have that option of pre-grant opposition only, this publication is made. So provisional application or complete application, and from that date, like 12 months for filing your international applications, and publication of application after 18 months, or by asking early publication within 4 months, the patent office will publish. And after filing a request for examination, so they'll examine it and they'll issue an FAR, first examination report, and for which like the applicant need to file a reply within 6 months. So once he satisfies all the questions, all the objections raised in the FAR, so the patent will go or gets granted. If the applicant or the agent representative, if he cannot convince or if he cannot answer all the objections, so then in that case, like it will be posted. So in the hearing again, like whatever the pending objections pending in the FAR, after reply to the FAR, so will be asked, and the hearing will be physical or through video conferencing these days. So the agent or the applicant can actually explain the differences when compared with the prior art, and also explain the reasons if there are any for formal objections. And then if required, like they have to file a written submission, and also if required, they have to file some certain petitions to condone the delay or the irregularity in the procedure. So on satisfaction, the controller will proceed to grant the patent. Or he may reject or refuse based on inventiveness, novelty, or so it can be appealed again the controller to review the decision once. And if not, so actually previously it is an appellate board. Actually, if the applicant is aggrieved, actually he can he can approach the appellate board for review of the controller's decision. But now the appellate board is repealed recently in last month. So there is no appellate board now. And now it is like we check court. So this difference, like we are discussing in the previous slide also, what is the difference between a patent publication, or what is the difference between a granted patent and a patent application published. So can a published paper be patented? Can someone answer? To be patented or anything like been disclosed publicly in their website through their product brochure or through a paper publication, can we file a patent over it and get a grant? Not, it cannot. Yes. So as per Indian Patent Act, at least 1 day is not allowed. That means like it is not file a patent. You can file a patent for a published paper. If you have any improvements, if you can show some technical advancement over the patent, over the paper being published. That means like your paper itself, your paper will become one of the prior art along with other citations. And if you can actually distinguish, differentiate, and show improvement, then in that case, like you can file a patent after your publication. But otherwise, if the same contents equivalent to the paper being published, in that case, like so your paper will become a citation for your patent application during examination. So what does publication date of a patent mean? The publication of a patent application marks the date at which it is publicly in applications worldwide. So the date of publication is very important in of a patent application. So that is the date where the complete information of the patent is available to be considered as a prior art for other patent applications which are being filed after our application. So this is the journal, actually official journal of the patent office. It will be published every Friday. Whatever applications been published in the preceding week. So those will be listed as an abstract title, and bibliographic information will be listed in this journal. So this is something like it is not similar to the papers published online in Scopus or any other mediums that you people actually publish, but it is something like a proof of your application, the first proof of your application actually online. So it will contain your title, the applicant's names, the first proof of your application online. And what is post-grant publication? So this is about the pre-grant or the application publication, and there will be a post-grant publications. So post-grant means after publication in the same journal. So whatever the patents been granted in that week will be published. Again, the entry will be given. So this entry will have the number of that have been granted and the patentees. That means like during the application, the applicants filed, but after the application in some state, so the application been assigned to a college, for example. So that detail, so the new patentee or the owner of the patent, so that details will be published. So as a part of post-grant publication. So examination of patent applications in India. The examination is only by by a request of request for examination. That means like the application fee is different, the publication fee is different, and examination fee is different. And even these three steps are not one, they are independent. That means like application separately, like as a provisional application, it can be filed, and after which like a complete specification can be filed, and a publication request is made, an early publication request is made, and an examination request is separately made. That means like all these three are not combined, are not one. So a separate request along with the application or after the application before 48 months need to be made. Only then the applications will be examined. So if you see some applications, for example, I should not say this, but colleges file the applications, or institutions, some of the institutions, like they don't know. So they are not aware that a request for examination need to be made. The agents who are representing will not intimate. They only say like the application fee will be communicated, the publication fee will be communicated, and the examination stage will be ignored. So that I want you people actually make note of it. So all this, like only after examination, only if it is granted, then it is called patented. So till then it is patent pending or patent application. You cannot say like I have a patented invention. So if you can say only you have patented invention if you have a grant. So the fee for examination request made in Form 18 is 4,000 rupees for natural person, startup entities, or small entities, MSMEs. And other entities like the colleges or institutions, it is 22 as part of Patent Act and Rules Amendment 2021, so that the institutions are brought under natural person category, so that like the fee will be only 4,000. That is not been approved yet. It is still actually in draft stage, where it may be approved in couple of months, and if that been approved, and even the public are, the proposal is for all the institutions, but there is no clarity whether the public institutions or the private institutions also will be part of it. So if the private institutions also will be part of it, then in that case, like the patent application from institutional side should increase. And there is an expedited examination under Rule 24C by way of Form 18A is being provided in recent past after 2016. First, it is given to NPIIT, an early examination apart from the Form 18 by payment of rupees 4,000 with Form 18A. An early examination option is provided for startups, and later after 2016 it is been provided to small entities recently in 2020, and also it is provided to natural persons with at least one woman, one female in it. For example, there are 3 natural persons in an application as applicants, and one of them are women. Then in that case, like that application is eligible for early exam by way of Form 18A. So that application can be proceeded to early examination. And apart from that, like startups, natural persons with one woman, and small entities. Apart from that, the government institutions or the institutions directly funded by government or the departments of government, and other grants or some projects funded by government institutions. So these are all actually proposed to have this early examination, and as well a fee waiver as part of the 2021 rules. So that may be possible in couple of months. So applicant is eligible under an arrangement for processing a patent application pursuant to an agreement between Indian Patent Office and a foreign patent office.
Sir, sorry for the
So
interruption,
there is
sir.
a scheme. Yes, yes.
Sir, your voice is breaking, sir. Sometimes we cannot hear you clearly.
Yes, ma'am. Yeah. I have a very bad actually connectivity. Still,
Okay.
I'm trying to. Yeah, I'll try to. Is it
Okay,
clear
sir.
now?
Thank you, sir. Yes, sir. It's clear now, sir. Thank you, sir.
Yeah. So an early examination has been provided. An early examination is provided to government institutions apart from startups, small entities, and natural persons with at least one woman. As of now, after 17/9/2019, and fee waiver is proposed for government institutions as well, private institutions in 2021 rules, which is pending, and which should be effective in couple of months. This is an important development in terms of amendment to rules and the benefit or the benefits given to startups or the women entrepreneurship cells and promotion of IP cells and IPFCs, and as well this program under Atal. These are all actually initiatives after 2016 to increase the filings in India and to bring grassroots level innovations to patents and then to products by Government of India. This is the Form 18A actually that need to be filed additional to the Form 18, and this should actually include a proof of the entity or the person. For example, if it is a natural person and one of them is one of the applicant is woman, in that case, like we need to provide a proof of that female, an identity proof to show like she's a woman and she is eligible under this form and section rule 24C. And the additional fee apart from the Form 18 fee is 4,000 for natural person with woman and startup and small entity. And there is no option for other entities other than these entities for men under this 24C to ask for early examination. A Form 28 need also to be filed along with the Form 18A to disclose like the type of applicant that claiming this option or asking for early examination under 24C. And regarding the objections related to novelty, this is the main thing. So novelty, non-patentability, and industrial applicability. These three are the important aspects for getting a patent grant. And in all of these three, non-patentability, we obviously check while filing the application. In some cases, like if the applicants are directly filing, maybe they are not, they ignore the section 3 in total, and they may file the applications which attract the non-patentability objection. But non-patentability is nothing but like the subject matter which is not eligible for patent. So in most of the cases, the main criteria or the main objection that we'll encounter is the novelty part. So the applicability part, that means like industrial applicability part, that means the invention having an usage will not come, and even non-patentability aspect will also not come, because like by knowing section 3 we know in most of the cases we won't file if it is not patentable. The only main aspect that the objection will be as per novelty as per section 21J. So novelty means like the improvement when compared with the citations or the claims that will have technical advancement when compared with the prior art. So if the claims contained in the patent application are not new or were known to the public before the filing date of the patent application or before its date of priority, the application may be rejected on grounds of lack of novelty. It is also called as inventive step, lack of inventive step. This one. So inventive step means features of an invention that involve technical advances as compared to existing knowledge that have economic significance or both. This is very important. So if most of the cases in while anyone file for a patent application, we generally see European patents or US patents, and we'll see their drafting standard, and we'll tend to draft in the similar way, showing all the components of the invention in main claim, and then actually writing its advantages or the working in the dependent claims. But that practice actually in total they'll see the application in other countries. In US or in Europe, the examination happens by seeing the application in total. But as per Indian Patent Act, so which is a old Patent Act actually, but it is easy to understand and also easy to get grants actually if you understand the requirement properly. So the Indian Patent Act says like you have to incorporate your inventive steps, the main inventive step which you want to claim, rather the advantages or the material properties in the claim, in the main claim. And then your advantages, and again not the advantages directly like the type of usages and all, but the working by which the advances are there, those things in dependent claims. We can have an example. I can show you something like how we write or you should have seen in our colleagues presentation earlier in the day. So the industrial applicability aspect may not come in all the cases, only in such cases like the invention seems frivolous or the invention seems not possible. Certain cases like the proposal seems like an invention and there is no prior art also, but you can see no use of that invention. So such cases only will be referred under lack of industrial applicability. So this is the main class or the section 3 and section 3A to section 3P actually. So there are subsections actually defining what are not patentable. I think like my colleague should have covered it, but I'll quickly run again to give a clarity. So section 3A deals with frivolous inventions. That means like a flywheel in a smaller smaller construction of it, like it may work very good and it may prove the principle is wrong, that the energy is not required to generate an energy, another form of energy, but this should not happen, or when you scale it up, so it cannot be possible. So only the energy, the natural law says like the energy can be converted or transferred or moved into another form, but you cannot create energy without actually spending anything. So that natural law will attract this thing under section 3A, like those type of inventions will be called frivolous inventions, and machines that give more than 100% performance are perpetual machines, cannot be patented, and these will be objected, and the FARs will, or the examiners will list them under section 3A, and they'll be rejected actually. And this is a machine wise, it is not it is patentable. It is not that it is not patentable, but the usage of this machine, example, a jackpot machine is not permitted to use in India. That is contrary to public order. So for that reason, though this machine wise it is perfectly okay to give a grant, but as the usage is banned, so it cannot be granted. And section 3C is a mere discovery or a scientific principle or formulation of an abstract theory. For example, superconducting phenomena as such, property of certain material to withstand mechanical shock and etc. So cannot be claimed, and if claimed also, they will not be granted. And section 3D is the important section actually, a mere discovery of new forms of known substance. That means, for example, we have a prior, in the recent, in the morning session I had, so there is a question from a participant. So she is actually collecting some raw fruits which are actually only available in forest and which are known to general public, which are not known to general public, and she want to conserve them in form of some pickles or from in the form of some jellies or in the form of dry fruits. And she asked whether we can patent it. So this comes under this section 3D. So you discovered something which is known, but which is not known to everyone, and you are actually proposing them by pre-processing them. So you are proposing their usage in a new form. So that should not be enough for getting a patent. And there are other sections 3F and which are not very much relevant to the audience today. But section 3F is again like the same like new form of usage. For example, hydrochloroquine been used to treat coronavirus. So which is a different composition which is tested on different disease, and the studies are also different. But as a lack of medicine for this situation, for this disease, so that has been used for some time or been used now. By showing that reason that has been used for different purpose. So the company who had already a patent for the composition and method for a different use, so they cannot, though the usage is not the claim, so they cannot refile the application again and get a fresh grant, so that it will be again valid for 20 years. So that cannot be possible under section 3F. And after section 3F, section 3G is repealed actually from the act, and section 3K deals with the mathematical or business methods and computer programs or algorithms. That means like all type of artistic works almost, and the computer softwares which are pure softwares which are not dependent on hardware or which cannot be shown as a system in a system architecture. So in that case, like they are not patentable under section 3K. And in this section, like most of the objections will be for softwares when they are claimed, and for business methods, so when they are claimed. So business methods are a new form of doing business, and for that business there could be a process involving a software, involving a mobile application or something like that. But it's all about buying or selling goods or services, and it's all about doing a business online or offline by this method. And these methods are not patentable under Patent Act in India under section 3K. But still there are software patents in India granted. So we call them computer related invention, CRIs. How they are granted, I'll give some examples, like later after the session. So if you want to see, there are still grants not exclusively claiming the software part, but the system architecture of the software in total, the application in total, and they had grants. And there are certain applications, lot of applications pending on date, so in Indian Patent Office. So this is section 3L, which deals with subject matters not patentable under Indian Patent Act, like literary, dramatic, musical or artistic works, cinematographic works, sound recordings, including software. Software comes under 3K, but 3L, other parts of other types of copyrightable items. So these are all copyrightable subject matters, which are not subject matters of patenting. And section 3M is an interesting thing. It's something like a method of learning a language or method of teaching. For For example, you people have adopted online teaching these days from last 14 months. And for example, if you one of you had um, devised an approach to effectively teach the classes online, and you want to patent it, so that cannot be patented, because like the part of it comes under business method for commercial use of delivering the learning, and some part of it will comes under section 3M, which actually deals with method of learning or method of teaching. And objections related to 3N, so which are like the Byju's way of actually visual display or teaching. Like there will be a video, there will be an audio associated with that, a person associated with it, actually explaining it using the software application. So that even that cannot be patented. Or this very presentation I'm presenting it to you for online. So if I want to patent it, I cannot do it. So it's only a copyrightable subject matter. I can, if I want to have an IP for this, the content and the structure of it and the images I'm using, if they are made by me and not disclosing the source of it, so in that case, like I can go for copyright of it, but I cannot patent it. And other important and the last section, I mean in section 3, section 3P, which deals with traditional knowledge. That means most of the food products are the processing of food processes, food products been claimed as patents. Most of them will attract this 3P. For example, the turmeric, the neem, the tulsi, or the other spices we use in our kitchen. We don't know when they are being used, from when they are being used, but they are being used from long enough, from ages, and by having a mere uh, composition of different ingredients, we cannot claim their medicinal properties or their original properties and get a grant in India. So this can be this is a subject matter of patent in US. So these things can be claimed in US, like combination of different ingredients and composition of it, and their usage and advantage can also be claimed in claimed under US Patent Act, but not in India. Till now it's clear, like I'm audible, and the slides are visible, and we are on time.
Yes, sir. Yes, sir. Visible, sir. Audible, sir.
And the types of claims are claiming formats that are not permissible. So usage claims are not permitted. Claims directed to methods of treatment or diagnosis are not permitted. Second medical use or third medical use claims are not permitted. Claims directed to plants, animals, or parts thereof are not permitted. That means like we can claim a composition, but we cannot claim a part of the claim. For example, a medicinal composition and a process of making it is claimed, and a plant which is classified, which is known, and we cannot say like I took some I took bark of that plant, and I want that plant name in my main claim. So we cannot do that. We can discuss, or we can disclose from where it is been sourced, what it is, how it is sourced, how it is cultured, or how it is been prepared, in what method. That we can all disclose in the description part. But in the claim part, the only method of preparing that medicine or that food product or processing of it can be claimed, and a composition of ingredients, but not the plants or animals or parts thereof. Claims directed to methods of agriculture or horticulture cannot be made. Claims of treatment or diagnosis or doing a surgery or something like that cannot be made. Claims that are directed to essentially biological processes for the propagation of plants or animals cannot be made. Other objections related to sufficiency of disclosure. This is the main requirement. So all we file, even I personally as an agent in my initial days, or depending on the client's inputs, sometimes like after we ask many times also, the clients will not provide any experimental data or prototype data or the lab or the considerations that they have made to select a material. All these information they won't give, maybe because of lack, because they don't have, or they didn't prototype it, or they didn't visualize it, or they didn't use any software to actually do the analysis or something like that, and lack of time, because like they should have filed it as provisional and there is a due date for complete specification, and they just give us the claim what can be made. They'll just give us a CAD drawing where like some parts are visible and some parts are not visible, and the working of it is not properly disclosed. This everything, that problem, the complete information related to invention, explaining how it is constructed, what is being used, what is the consideration for using those materials, and how it is working, and what is the actual claim when compared to prior art, what is the differences. This everything should be there, and if it is not available, so there will be an objection related to sufficiency of disclosure. And with this objection also, there is definitely a chance that the controller may refuse the application, even the invention is patentable. Other objections related to clarity and conciseness. So clarity and conciseness will come by usage of extensive and sophisticated language, like the words plurality, at least one or more, etc. So these things, like to keep the claim broad, and the claim the granted invention to have a broader perspective in thought. Actually, people try to incorporate these words uh, more than enough or more than required, and then it all leads for lack of clarity. So those words are to be avoided to a maximum extent, and only to be used wherever required. Other objection related to definitiveness. Again, definitiveness or the clarity, both are hand in hand. So again, definitiveness means like we have to be confined to one inventive step only, not using multiple inventive steps or claiming multiple inventions in one application. So we have to be definitive while we are actually writing the claim, and writing the claim, and we have to be careful that the main inventive step is properly drafted, and this objection can be escaped actually. I hope like I'm clear till here, and the voice is audible, and the slide is visible. Can someone confirm, madam?
Yes, sir. Visible, sir. Audible, sir.
Yeah. So another 15 minutes actually. So other objections in the examination report will be related to the formal objections. That means like not filing the power of authority or the authorized signatory authorization from the company if it is filed as an entity. So whoever been signing the application on behalf of the applicant, so he has to have a board resolution or an authorization letter from the other parties or other members of the company. Or if the application is being filed by a patent agent representing that applicant, then a power of attorney duly notarized or duly stamped should be filed, and that to be filed within 6 months from the date of filing. That is a compliance, and if that is not been followed, this will be an objection in the examination report. A proof of right, that is form 1, with all the details, with the agent details, with the applicant details, with the inventor's details, and with the inventor's signatures declaring the ownership transfer to the applicants. And the end of the form, like the applicant signature, a proof of right for the application has to be submitted. And if it is not submitted, it will be a main objection, formal objection. And a form 3 declaring the foreign applications being filed and their status from the date of filing. That means like a Form 3 need to be filed within 6 months from the date of filing, disclosing if there are any foreign applications associated with this application. For example, if there are foreign applications after the application been filed and after 6 months, once the Form 3 is already filed, that means like a Form 3 every time after a foreign application been filed need to be filed with Patent Office to disclose or to notify the Patent Office about our file history or about the foreign application being made. I'll show you an example for that in my next slide. Form 5 need to be filed. Form 5 again an endorsement from the inventors declaring that the ownership been transferred to the applicant. So this is also need to be filed, and the requirement is like within 1 month from the date of complete specification, this need to be filed. And an assignment deed in the case of, for example, there are inventors, 4 professors or participants, there are one application been made in the name of college, for example, and the college is having the right. In that case, like an assignment deed, apart from the endorsement from the inventors, so an assignment deed need to be provided in proper format with proper stamp duty, and that need to be provided along with Form 5 and proof of right. And obviously, a request for examination has to be filed. If a request for examination is not been filed, then the application will be abandoned after 48 months. So this is the example Form 3. So in this application, if you see the dates, the original application in India is made on 21st February 2011, and there is a PCT application filed within 1 year in 2012 on 17th February 2012, and on the same date of PCT, they filed a UK application, US application, Malaysia application, and as well Indonesia application. So, and these patents, for example, UK application is granted on 26th August 2014. US application is granted on 29th March 2016. Malaysia application is granted on 15th May 2017. And in Indonesian application is been withdrawn by the applicant himself. By this time, for example, so 2011, the application is filed. And even till 2017, the application in India is still pending. As it is still pending, these all dates need to be communicated in separate forms within 6 months from those dates. That means like a Form 3 need to be filed within 6 months after 21st February 2011. And again, a Form 3 need to be filed. Presentation, I have an issue with the presentation actually. So a Form 3 after the PCT application need to be filed within 6 months. And a Form 3 again after the grant of UK application need to be filed. And a Form 3 again after US grant is need to be filed. A Form 3 after Malaysian grant is need to be filed. And again a Form 3 after the Indonesian is need to be filed. That means at least 7 Form 3s are to be filed for this application. So this is the case here for this application, and the next slide actually I'll take a minute here because like so as the signal is low, I have to roam around in my house. So the computer actually went into sleep mode. So till here, any questions actually?
Participants, I kindly request you to post your questions either in the chat window or unmute yourself and ask the questions. So there is a question, what are the steps for filing an international patent? Example, US patent.
Yes, ma'am. The right example I shown this Form 3 for that particular application. The first application is filed in 2011, and again they have to. The requirement is like they have to file their international application. For example, if this is the case, like the participant's case, so if she is filing 2021 on 28th July. So she has to her international applications by next year the same day in all the countries wherever she is interested. And if she is not ready, she needs more time. So in that case, before that day, again the same condition, 12 months before she has to. With the PCT application, she'll get more time, 19 months more time. That means like 28th July 2020 is 2021 is her priority date. That means the home country application date. And the last date to file, if it is convention applications, other countries, the last date to file international applications is 28 July 2022. And with PCT, she can extend that date by 19 months more. That means almost by December 2024. So December 2024 will be her last date to file international applications. International means, again, the individual applications. Any application in each country, if they want to have a right, they have to file an application, the same application in that country, and they have to go through the patent examination process there. But the thing is, like the Form 3 requirement, if you see, the same way even the other patent offices will have the same requirement. Why is that requirement? Is to have the knowledge of the same application in different countries, so that like if there is a grant in one country, they'll automatically grant in other countries also. But the process should be followed.
Thank you, sir. There is another question, sir. What is the difference between the inventor, an applicant, and a patent? Do the inventor and the applicants get the same weightage in the patent publication?
As per Patent Act, any Patent Act, like the inventors are default owners. That means like the inventors are the applicants and the owners, unless until it is defined. And if it is defined in such a way, for example, there are 3 inventors and only one applicant. For example, 3 inventors means like 3 inventors like you, for example, your colleagues from computer science department, you 3 people are inventors. And if the application is being made on Pratisha College of Engineering, then the applicant and owner is the college, and you 3 people are only the inventors. So you won't have any ownership. So the ownership can be defined in the application itself, or it can be defined at a later stage also. But whoever the applicant is the owner. And applicants can be combination of institution, combination of a private company, combination of a government department, and combination of natural persons, and there is no limit on it.
Okay, sir. Thank you, sir. Another question, sir. Sir, if we have a Indian patent, can we patent the same for international? What are the advantages of international patent over Indian patent? Any suggestions for finalizing or invention for Indian patent or international patent?
I think like the same question, ma'am. The first question also. So the grant in other countries is to do business, right? So the grant is for a protection of an invention in that country. So first, any applicant he'll see his market or his potential market, or at least if he is not planning immediately for manufacturing or commercializing it, so first they plan to file in their home country. So after the first application, it could be home country or it could be any country. That means like it can be filed outside also. For example, Indian national, for example, the participant, whoever is asking this question, so without filing an application in India, they can also file it in US directly. But only thing is like they have to notify the patent Indian patent office that they are interested in filing in US, not in India first. So that need to be notified, and they can file the application there. So wherever it is filed, that application will become the home country application, irrespective of the nationality of the applicant. The first application is technically called the home country application. After the home country application or the priority application, we also call it as priority application or priority date. From the priority date, the same application need to be made wherever it is it is interested, wherever it is like the market is. So the purpose of grant is like whether to file international patents or not is yours. That is a business call.
Thank you, sir.
Indian
Participants.
patent application prosecution is the cheapest one when compared with any other country. So the decision, the main component for decision to make foreign applications is the cost, obviously. So based on it, based on the product capability, you have to plan your foreign applications. But irrespective of whatever it is, like you have to make your applications wherever you are interested, and you have to get the grants, and you have to maintain as well after the grant.
Yes, sir. Thank you, sir. Any other questions from participant side?
And you have to allow me Yuva Patent Services login actually to share the screen now.
Yes, sir. Already it has been.
Actually, it got I came out of it and I joined again.
Yes, sir. Now I have
Yeah.
done it. Yes, sir.
Yes, ma'am. There are very not more slides. Actually, this is the form 3 that we are discussing. And here in this case, like the applicant is interested, they first filed in India, and they are interested in filing in other countries. So they filed a PCT also so that like they'll get more time to decide on other countries. And they already decided on UK, Australia, UK, US, Malaysia, and Indonesia, and they filed them. So this is the way to proceed. Like once you file your Indian application, you have to think about foreign applications, whether it is granted in India or whether it is pending in India. So this case, like it is pending in India by the time they filed the PCT and international applications. But with the option of early examination given these days, previously the Indian application used to take at least 7 to 8 years. And this particular application, though it is filed in 2011, it has been granted in 2019. So likewise, like it used to take 7 to 8 years or 6 years or at least 5 years to get a grant. But now it is very fast, like less than 1 year, like with the option of early examination. So we are getting grants. So that is also one important thing, like that is beneficial to applicants to decide on foreign applications. Because without knowing like whether it will be granted or not, so you cannot decide on whether you file in other countries or not, because like it is very costly in other countries, and that is also one factor. So if it is granted in one country, at least some investor or some way like you can convince someone to fund to file in other countries. So this is form 5, like an endorsement from the inventor to the applicant. In this case, like inventor and applicant are same. So, but still we have to file this endorsement. In a case like inventors are different and applicant is different. So then in that case, like inventors details are given here in the top, and title of the application and application number, and given to the rights are given to assign all the rights pertaining of the aforementioned patent application to the applicant, so and so. So this need to be filed within 1 month from the date of complete specification, before 1 month from the date of complete specification, or yeah, it can be filed along with the application itself within 6 months. So this is where this is how the IP portal like looks like when you log in. If you have a dedicated login for your IPFC or for your own, like for as an applicant, or for example, this is my login. So as an agent, so everything like the options are same for all, whatever the type of login is. So all the things like this is something like this is not a dashboard. The portal is designed such a way like it doesn't give you your previous applications by number, or you cannot search whatever been filed. Only you can file whatever forms needed, and you can see the filed forms history. So it is not a dashboard type of thing like you'll get a one single dashboard or a page, master page that to show all the applications been filed and their status is latest status and all. So maybe that could be a state in future, but for now it is a file history type of portal. Like you can file all the forms required and only see whatever the forms been submitted as a file history. So a reply to FAR within 6 months need to be filed with an extension permissible up to 3 months, and this extension need to be taken at once. If you are interested to take 1 month, you have to take it 1 month, or if you are interested to take 3 months, you have to take it 3 months at once. You cannot make multiple requests to extend this date. In case of post dating of the application, you can make multiple requests. First, you can take 10 days. Again, you can take 10 days. Again, you can take 1 month or so, up to 6 months. But reply to FAR need to be made within 6 months, or an extension in Form 4 can be made up to 3 months, but only once. Fresh and marked copies of amended complete specification need to be submitted along with FAR reply. And if there are any formal objections related to Form 1, 3, 5 and power of attorney, and any petitions need to be filed, because like of in case of you miss the dates, timelines within 6 months, Form 26 not filed within 6 months from the date of filing. Form 3 not filed within 6 months from the date of that entry. Form 5 not filed within 1 month from the date of complete specification. Proof of right not filed within 6 months from the date of filing. So if something is been missed, so you have to file a petition under section or under rule 137. So to condone the delay, to ask the controller to waive off the objection and to correct the irregularity. And also, if there are any amendments made, so no amendments are actually technical amendments or new content need to be added to the complete specification during the examination report or to the drawings. You can only file an affidavit separately along with the FAR reply if you want to submit more information. You cannot add anything additional, anything. You cannot even, you can only correct some grammatical, not even grammatical. You can only correct if there are any spelling mistakes, type errors. So you can only correct any type errors, and for that also you have to make a Form 13. You can only amend the complete specification, that to the claims part, showing the source of it, showing the source of it in the specification or the description part. That means like you cannot add any new content. You can just reframe the sentences. You can refer to the description wherever that has support, and then you have to submit along with the FAR reply. I hope I'm clear on my topic, and if you have any questions more apart from this topic as well, and any scenarios that you are facing with the patent applications already existing, or the patent examinations replies already filed, and so you can definitely ask. Yes, ma'am.
Dear participants, if you have any queries, kindly ask to our guest.
Is that question of Anand Kumar got cleared? So he's asking about advantage of international patent or Indian patent. Advantage all depends on the business call, sir. So it is not that US patent will have more weightage or Indian patent will have less weightage. There is a notion that way, like if you ask someone who lives in US, like he'll say like US patent will have weightage, not the Indian patent. It's not like that. It's a proof of your invention, like the novelty of it, any grant, in India or US, it's a proof that you have a novelty in the invention and you got a grant, and that may lead to a business. So if you are the business call, why I'm telling that word is like, if you can afford, you can definitely file in US after filing it in India. You can also try filing it in Europe, as because Europe is one application, but for all of the 34 countries, it's one application including UK. That means like you are having one grant for all the countries, but again after grant you have to maintain. That means like you have to pay renewal fees of all the countries every year. That is a tedious thing. We can file in India, and if someone is not sure of what next with the invention, in that case, like you can also file it in US, because the cheapest source after India is US only. The application fee is around $490 official fee, and the same application, whatever you file it in India, you'll file it in there also. That means like there is no additional cost of patent agent drafting the application. Only you have to engage an agent who can actually file the application. So that also you can get it under reasonable cost. And if the claims are drafted properly, there is no need, like in the prosecution stage, also in the examination stage, also there is no much cost. It may cost you $500, $600 if there are any pending objections to clear off. So, and you'll get a grant. And even after grant, there is a fee. On grant, there is a fee in US Patent Office. But after that, there is no yearly fee. Only after 3.5 years. So, for example, it's not similar to Indian case. The US case is different. US renewal fee payments are different. So they'll take on grant, and again they take renewal fee after 3.5 years from the initial, from the grant date, and again they'll take they'll take after 7.5 years from the date of grant. Likewise, at least affordable costs when compared with other countries. So you can take a call based on that. Otherwise, like it's not. I mean, there is no advantage specifically with the type of, or with the country that you, with the country grant you that you will have.
Yes, sir. Thank you, sir.
And there is no one single patent grant for international. That means like there is no international patent at all. We call it as international patent. The PCT application will itself, PCT application is called as international patent application, but not international patent. Patent application is different, patent is different. There is an international patent application, that is an entry giving more time and giving a search report so that you can decide on where to file, when to file. So that is international patent application, but there is no international patent.
Yes, sir. Thank you, sir. Thank you for your session, sir. I hope there are no questions from the participant side.
And initially, one question is there from Sudhakar Singha. What if the patent, what if the paper is published through a learned society? If it is open in a learned society, then the paper can't be filed. Anything, sir, unless it is been submitted to a government approval. For example, you filed it for a DST approval or DST grant. There you disclose your invention. That won't be counted as a prior art, because like it is not open to all. It's only because it's only between you and the DST. And you submitted a paper in your college, for example, in a conclave or in a webinar like this, saying your this thing, like whatever the proposal is and what are the results are about. So that cannot be considered as a prior art. But if you are publishing in an international journal or some sort of a public domain, then it is a prior art. It is a citation for your own application. In US, it is different. They'll consider 1 year time. from the date of publication. Their act is different, and there they have to show the lab logbook and all, your working, your bills, whatever the proof they'll ask. If you are claiming that date, there they'll consider 1 year time after publication. But Indian Patent Act doesn't support that. And there is a question, Dr. Bhumika Das. What is the difference between the inventor and applicant in a patent? I think like we answered it. Do the inventor and the applicants get same weightage in patent publication? There is no weightage concept, ma'am. Only applicants will have the ownership. Inventors are inventors. Just to have it as in your profile and as you worked in that invention, it's only a proof of it, and that's it. So there is no weightage concept. As a proof of you working in the invention, it's something like the patent application publication will have the inventor's details also along with the applicant's details. The ownership is important here. The ownership is with the applicants. And that ownership can be defined while filing the application, and even it can be assigned to people between, like, for example, one application I'll give you. So there is one person, actual person actually filed this application. He assigned after grant to his company, and that company again reassigned that patent after some time to the applicant. So it can be transferred like a property. No one asks why you are transferring it. You have to show what is the basis of transfer, whether you have a consideration amount, you are transferring it between. For example, you filed your application and your college is asking that application to transfer it to them. So whether if they are paying something to you, you have to show it in the agreement. That's it. Or if you are just transferring it because like the college is your employer, as per your employment agreement, you are transferring it. So initially you can file it in your name and you can transfer it to the college, or college can transfer it to you. All good, sir? All good, ma'am? Any more
Yes,
questions?
Yes, sir. Thank you, sir. Thank you so much for joining with us, sir. Thank you for your precious time, sir.
Thank you very much. Sorry for making you wait. Actually, there is a small clash with sessions. So I had a session from morning 9:30 and it is almost till 12 o'clock. And I promised I will join by 11:30. Actually, initially the schedule 11:45 again, and again it's 12. Sorry for that. And a good thing like this is a very well planned sessions, and I hope like the participants are enjoying and getting more information. They are lagging at IP, and all the best for all of them, and for the upcoming sessions also. And thank you very much for inviting me. Thanks again to the Pratusha Engineering College and giving me this opportunity. Thank you. Thank you all.
Sure, sir. Thank you, sir. Thank you so much, sir. Thank you, participants. You can now move for lunch, and please do join back by 2 p.m. Thank you all. Thank you, sir.